Thank you. Subcommittee on the Constitution, Civil Liberties, and Civil Rights is now in session. We will come to order. Without objection, the chair is authorized to declare recess of this subcommittee at any time. I welcome everyone to today's hearing on the Equal Rights Amendment. I will first recognize myself for an opening statement. I'm pleased today to convene today's hearing on the Equal Rights Amendment for the purpose of carrying out one of this subcommittee's most important functions, the consideration of an amendment to the United States Constitution. The purpose of the ERA is simple but critical. It guarantees that women are treated equally under the law. The ERA was in fact approved by both the House and Senate nearly half a century ago. In 1971 and 1972, it passed with overwhelming margins. The Constitution instructs that after a proposed amendment receives the required 2/3 of the vote in each of the houses, it has to be ratified by 3/4 of the states. After the ERA was sent to the states in 72, it was ratified by 35 of the necessary 38 state legislatures. But for decades, that extraordinary progress toward equality stalled. A well-organized counter-movement scared the American people into thinking that a guarantee of equality would somehow harm women who stay at home to raise their children and would erode American families. What had started as a matter of broad consensus became another divisive issue in the culture wars. Today, we know better. We know that in the year 2019, it is unacceptable that women still are not paid equal wages for equal work. We know that when women are treated with equal dignity and respect in the workplace and the home, by our institutions of government and our society at large, all of the American people stand to benefit. And we know that a simple but fundamental guarantee of equality should be welcomed rather than feared. At the same time, it is more important than ever to affirm that women have an equal place under the law and under our nation's Constitution. Although women have achieved some measure of equal status under the 14th Amendment, that progress is fragile. As the Supreme Court has moved to the right, it could backtrack from fundamental decisions, as it has in other areas, and jeopardize the many strides that women have made. Meanwhile, there are dark currents in our politics and culture seeking to undermine women's status in our society, whether it's by threatening their health care, objectifying women in the workplace, or ignoring or even condoning gender-based violence. In the face of those challenges, I am heartened by the two panels and the extraordinary attendance we have here today. Your presence demonstrates that the march toward equality is alive and well. I'm also very, very pleased to recognize two outstanding members of the Congress, two of my colleagues, Congressman Carolyn Maloney of the state of New York and Congresswoman Jackie Spear, who will be speaking today. Jackie is a California. And they have introduced two different propositions to get the Equal Rights Amendment rolling again. Congressman Maloney has worked tirelessly as an advocate for the new ERA, and Congressman Spear has introduced a resolution, H.J. Res. 38, to guarantee that the 72 ERA is not subject to an arbitrary ratification deadline. Their extraordinary efforts have ensured that the important unfinished business of passing the Equal Rights Amendment is not forgotten, and I'm proud to be a co-sponsor of both measures. I'm also pleased that our chairman has championed this issue and has worked strongly to move it forward over the years and to have this hearing, and I thank Chairman Nadler for his efforts therein. We're joined by two stars of show business. Well, maybe more, but at least two that I know of, Ms. Patricia Arquette and Alicia Milano. We welcome their attendance here. Ms. Arquette will be on the panel. Ms. Milano, if you would rise and be recognized, I would appreciate it. Thank you. I think it's so appropriate that we have these two giants of the industry with us, because one of the best plays on Broadway today is a play that Heidi Schreck wrote called The Constitution and Me. It's a powerful play about the Constitution, penumbral rights, Justice Douglas, but emphasizing women, choice, and the ERA. So thank you, Ms. Schreck, and thank you for all of the industry that is working to see that we move forward on this issue. A few years ago, a great woman, a great person, Justice Ruth Bader Ginsburg, was asked in an interview what amendment she would most like to see added to the United States Constitution. She answered it would be the Equal Rights Amendment. As she explained, the ERA means, quote, that women are people equal in stature before the law, unquote, and that, quote, that principle is in every constitution written since the Second World War. Justice Ginsburg said she would like her granddaughters, when they pick up the Constitution, to see that it is a basic principle of our society. I understand there's a possibility that Justice Ginsburg is watching today's hearing, and just to channel our president, Justice Ginsburg, if you're listening, get us the ERA. I look forward to that day and to the discussion among today's witnesses. Now I recognize the ranking member, my friend and colleague, Mr. Johnson.
Thank you, Mr. Chairman. Thank you all for being here. This is an important part of our democracy and our system, and your voices are important. The Equal Rights Amendment, the so-called ERA, was first introduced in Congress back in 1923. I know you all know the history of that. It was passed on to the states by Congress in 1972, ironically the year I was born, Mr. Chairman. This has been around a while. But it wasn't ratified by the required 3/4 of the states before its expiration. In 1983, the ERA was reintroduced, as it had to be following its failure to be ratified before the congressionally set deadline, a deadline that was explicitly relied upon by those states. It was the subject of 5 hearings in the House Subcommittee on Civil and Constitutional Rights, including one hearing called by the minority. It was last debated and marked up in the House Judiciary Committee on November 9th, 1983. It's been quite a while. It was later brought up on the House floor under a suspension of the rules, in which no amendments are allowed, and in which 20 minutes of debate time each was allocated to proponents and opponents. The ERA subsequently failed to pass the House of Representatives by the required 2/3 vote. Today, this subcommittee holds yet another hearing on the ERA, which, as we will hear, will have to be passed by Congress and the states under the Constitution's supermajority requirements before it becomes a part of the Constitution. It should not become a part of the Constitution, many of us believe, for a number of reasons, including this one. The bipartisan Hyde Amendment prohibits the use of federal funds for abortions except in cases of rape, incest, or when the life of the mother is endangered. The Supreme Court upheld the Hyde Amendment's abortion funding restrictions as constitutional in Harris v. McRae. But the people's right to protect the unborn would be eliminated if the ERA were to pass. Back in the early 1980s, Representative Sensenbrenner requested that Congress's independent research arm, the Congressional Research Service, provide the committee with its own evaluation of the question. As he said at the 1983 markup of the ERA, quote, "The executive summary of the CRS report says that under strict scrutiny, the pregnancy classification in the Hyde Amendment would probably be regarded to be a sex classification under the ERA, meaning that if the ERA were to become part of our law, restrictions on abortion would automatically be struck down." Today, however, with the benefit of even more recent history, we can see that the concerns of Representative Sensenbrenner in 1983 were justified. 5 years later, in 1988, the Colorado Supreme Court held that Colorado's ERA and its state constitution prohibits discrimination on the basis of pregnancy. 10 years later, in 1998, the Supreme Court of New Mexico took the next step and relied on New Mexico's state-level ERA to strike down a state reg that restricted state funding of abortions for Medicaid-eligible women. In New Mexico v. Choose NARAL, New Mexico to Right to Choose, NARAL v. Johnson, the court held as follows, quote, "Neither the Hyde Amendment nor the federal authorities upholding the constitutionality of that amendment bar this court from affording greater protection of the rights of Medicaid-eligible women under our state constitution in this instance. Article 2, Section 18 of the New Mexico Constitution guarantees that equality of rights under law shall not be denied on account of the sex of any person. We construe," the court said, "the intent of this amendment as providing something beyond that already afforded by the general language of the Equal Protection Clause." More recently, NARAL Pro-Choice America, in a March 13, 2019 national alert, admitted their belief that the Equal Rights Amendment would, quote, "reinforce the constitutional right to abortion. It would require judges to strike down anti-abortion laws," unquote. Look, of course, we all believe, I'm the father of 2 daughters, one of them is sitting in the room this morning, that women should be protected from discrimination based solely on their sex. And that is the law today. The Supreme Court has significantly ratcheted up the standard the government must meet in order to discriminate based on sex since the 1980s. For example, in U.S. v. Virginia, the court stated that, quote, "parties who seek to defend gender-based government action must demonstrate an exceedingly persuasive justification for that action. The court also stated, the burden of justification is demanding and it rests entirely on the state. As Justice Rehnquist noted in his concurrence in that case, the court had in effect made the government's burden much more difficult than it had been previously. Justice Scalia, in his dissent, pointed out that the standard governing review of the government's actions that discriminate based on sex that had previously been in place was, quote, a standard that lies between the extremes of rational basis review and strict scrutiny. We have denominated this standard intermediate scrutiny, and under it have inquired whether the statutory classification is substantially related to an important governmental objective. Yet in U.S. v. Virginia, Justice Scalia pointed out that the majority in that case had, quote, executed a de facto abandonment of the intermediate scrutiny that has been our standard for sex-based classifications for decades, unquote, and replaced it with an even higher standard, he said, which is the law today. The majority opinion in U.S. v. Virginia, it should be noted, was written by Justice Ruth Bader Ginsburg. And hello, Justice Ginsburg, if you're watching us. In the 1970s, she was intimately involved in the preparation of a report published by the United States Commission on Civil Rights in 1977 that specifically supported the federal ERA, as you know, along with its ramifications. If it's adopted, it would include the elimination of the terms fraternity and sorority chapters, for example, and the required sex integration of single-sex organizations, among many other things that I think most Americans today would probably object to. With that, we look forward to the hearing from all our witnesses here today. We certainly respect your voices, and we're glad you're a part of the process. I yield back.
Thank you, Mr. Johnson. And what's your daughter's name?
Abigail.
Abigail, welcome. I was a friend in college of somebody in your, William Dawson Larry. He was somehow your cousin or your uncle or somebody a long time ago. Smart, good guy. And so is your father. I now recognize the full committee chairman, the great congressman from the great state of New York, the Empire State, Mr. Nadler.
Thank you for that florid introduction, Mr. Chairman. And thank you for convening this critical hearing. The first version of the Equal Rights Amendment was proposed nearly 100 years ago by Alice Paul, who helped lead the campaign to secure women's right to vote, which culminated in passage of the 19th Amendment. She and the other courageous women who led that movement soon recognized that ratification of women's suffrage was only the start. They knew that if women were to achieve true equality, our nation's founding document needed to be amended to reflect that core principle. Alice Paul's Equal Rights Amendment was introduced in both houses of Congress in 1923. But 96 years later, the United States Constitution still does not explicitly declare that women have equal rights under the law. We have, of course, made important strides, in large part thanks to the brilliant legal strategy pioneered by now Justice Ruth Bader Ginsburg. The courts have recognized that the 14th Amendment prohibits many forms of outright discrimination. But in troubling ways, women's rights have begun to slide backwards in recent years. This administration continues to threaten women's health and safety on an almost daily basis, whether it is by trying to roll back laws that prohibit health insurers from charging more to women just for being female, or by allowing women's health care choices to be dictated by their employers' religious beliefs. Women still earn only 80 cents for every dollar that men earn, with women of color earning even less. And they have uneven protections against other forms of discrimination and against harassment in the workplace. With these disturbing facts in mind, and I would add to my written text one, I'll go off script for a moment, we have a Supreme Court that has been so sympathetic that when Congress passed the Pregnancy Discrimination Act in 1978, you can't discriminate against women who are pregnant if you're an employer. The Supreme Court has interpreted that to mean that if you behave decently toward other employees, you have to behave decently toward pregnant women. But if you're terrible toward other employees, you can be terrible toward pregnant women, and they don't need any consideration. With these disturbing facts in mind, it is clear that an Equal Rights Amendment is more important than ever. Members of Congress regularly debated the ERA from the 1920s through the 1970s, but the issue has largely remained dormant in recent years, making this hearing long overdue. In 1971 and 1972, the House and Senate passed the ERA by overwhelming margins. It contained these simple words, quote, "Equality of rights under the law shall not be denied or abridged by the United States or by any state on account of sex," close quote. One would think that shouldn't be terribly controversial. In the years that quickly followed, dozens of states ratified the ERA through their legislatures. By the end of the 1970s, the ERA was just a few states short of full ratification, but then progress on the amendment stalled. Thankfully, due in large part to the hard work of several of the witnesses here today, the momentum has picked back up. First, Senator Spearman led the effort to ratify the ERA in Nevada state legislature. Illinois followed suit last year. Meanwhile, women have been elected to office in unprecedented numbers, including here in this Congress. Now, for the first time ever, more than 100 women are serving in the United States House of Representatives. 106, in fact. Some of the women who are part of this inspiring wave are on this subcommittee, and they are helping to lend their voices to the critical effort to ratify the ERA. In addition, H.J. Res. 38, introduced in this Congress by Congresswoman Jackie Spear, with 185 co-sponsors, would ensure that the ERA can become law if and when a sufficient number of states ratify it. Although there is some debate about the mechanism for determining when a sufficient number of states have ratified the ERA, I hope there is no debate about the need for enshrining in the Constitution a clear and firm statement guaranteeing women equal rights under the law. We are on the verge of a breakthrough for equality in this country, despite all the obstacles in our current political and social climate. Adopting the ERA would bring our country closer to truly fulfilling our values of inclusion and equal opportunity for all people. I thank the witnesses for their participation, including my colleagues, the gentlewoman from California, Ms. Spear, and the gentlewoman from New York, Ms. Maloney, who have both been champions for the ERA and have done much to bring us to where we sit this morning. I look forward to their testimony and to the testimony of all our
We welcome our witnesses and thank them for participating in today's hearing. Please note that your written statements will be entered into the record in their entirety, but your oral statements will be limited to 5 minutes. So to stay within that limit, there are lights on the table. When the light switches from green to yellow, you will have 1 minute remaining to give your testimony, and when it turns red, over. Before proceeding with the testimony, I want to remind each witness that all of your written and oral statements made to the subcommittee in connection with this hearing are subject to penalties of perjury pursuant to 18 U.S.C. 1001, which may result in the imposition of a fine or imprisonment for up to 5 years or both. On our first panel today, our first witness is Congressman Carolyn Maloney. Congressman Maloney represents the 12th Congressional District of New York. She has been a member of Congress since 1993. Among her many accomplishments, she is the lead sponsor of H.J. Res. 35, which proposes a new equal rights amendment. Congressman Maloney, you are recognized, and if you don't mind, just for 3 minutes. But I'm not going to cut you off if you take 8. Thank you, Congressman Maloney.
Thank you so much, both chairmen. I can't tell you what this means to me personally. But today, although there are 2 bills in front of Congress, today we are focusing on Jackie Spear's bill. Mine is a fallback bill, so that I feel it's appropriate that Jackie should go first since it's her bill we are reviewing today.
And I will not argue with Congressman Maloney.
Okay.
I will recognize our first witness, as I earlier said, Representative Jackie Spear.
Okay.
Mr. Chairman, thank you.
Representative Spear represents the 14th Congressional District of California, a member of Congress since 2013, and she's been the lead sponsor of H.J. Res. 38, which removed the ratification deadline. Congressman Spear, you have the 3 and 8 minute rule as well.
Thank you, Mr. Chairman, and thanks to you and Chairman Nadler for this extraordinary, historic opportunity for all of us to speak on the ERA. 36 years since Congress had a hearing on this issue that affects every single woman and man in this country. I want to thank the ERA Coalition co-founders and co-presidents Carol Jenkins and Jessica Neuwirth, Feminist Majority President Ellie Smeal, National Organization for Women President Tony Van Pelt, actors and activists Patricia Arquette and Alyssa Milano. This has been a lifetime campaign for many of us, a lifetime campaign. It doesn't start in 1923 with Alice Paul, actually. We have been an afterthought in this country since the beginning of this country. Back in 1776, when then Congressman John Adams was going to work on the Constitution, it was his wife, Abigail Adams, who said, "Remember the women." We want you to finally remember the women. Without constitutional protection, pay disparities will continue to be allowed in this country because of the high obstacle of showing that there is intent to discriminate in order for a woman to prevail in court. This is real. 50% of the major breadwinners in families today are women with children. It is time for us to take this issue seriously. And to Mr. Johnson, let me say, this is not a stalking horse for abortion. This is pure and simple 54 words that we want to add to the Constitution of the United States, because every other industrialized country in the world already has it in their Constitution, except for the United States of America. I'm the co-sponsor of HJ Res 38, which is a bipartisan joint resolution co-sponsored by 185 members of the House of Representatives, including Senator Ben Cardin on the Senate side. This resolution removes the arbitrary deadline from the preamble of the original constitutional amendment. It recognizes that Congress is fully within its rights to adopt a new deadline, as it has in the past, or to remove it altogether. I also want to recognize that Congresswoman Carolyn Maloney's resolution to ratify the ERA is something I endorse, and we work hand in hand. Because of the absence of the ERA, it's a stain on our Constitution and our country. Nations around the world have looked to the United States to model their constitutions and have recognized the equality of women and men under the law, yet we fail to do the same. It's frankly an embarrassment. An amendment that was supported by Republicans and Democrats under Presidents Nixon, Carter, and Ford have been used to divide our country, and it has allowed critics to claim there is no need for the ERA. To them, I offer the words of the late Supreme Court Justice Antonin Scalia, who said, quote, "Certainly the Constitution does not require discrimination based on sex. The only issue is whether it prohibits it. It does not." Now that should send chills down the spine of each and every one of us, that discrimination is not prevented against women in the Constitution of the United States. I will just say, Mr. Chairman, I've already exceeded my time. I will just end by saying that we need the ERA so that we can join the rest of the industrialized countries in the world and not be bringing up the rear as we are presently doing. We need the ERA so that we can achieve our full economic and social potential. We will no longer allow ourselves to be an afterthought. We need the ERA now.
Thank you so much, Congresswoman, and I can't not mention remarks, as a follow-up to your remarks. It took over 130 years to give women the right to vote in the Constitution, and that Tennessee was the perfect 36th state to do that in 1990. I now recognize the gracious Congressman Maloney.
Thank you for sharing that historical and very important point, and thank you, Chairman Nadler and Ranking Member Collins and Chairman Cohen and Ranking Member Johnson. And most of all, I want to thank all of the advocates and champions who have been working on this issue for years and trying to pass and ratify the Equal Rights Amendment. First, I'd like to respond to Mr. Johnson. With all due respect, the Equal Rights Amendment has absolutely nothing to do with abortion. It has to do with equality of rights, most of which is economic and respect. It has nothing to do with abortion. Saying so is just divisive and a tool to try to defeat it. So please don't ever say that again. And I really want to say,
Can't do it.
first of all, I want to thank my very good friend and colleague, Jackie Spear, for her leadership. By having both my bill to restart the process and her bill to extend the deadline on the original process, we're covering all of our bases. Some have called the ERA just a symbol. And keep in mind that symbols are important, like the Statue of Liberty, the American flag. Yes, it is a symbol, but women need much, much more than a symbol. We need respect, we need fairness, and we need to be in the Constitution. Not having an ERA has real consequences for real women. We cannot enforce equal pay for equal work unless the ERA is in the Constitution banning discrimination. It's that simple. And there are numerous court decisions that show the need for the ERA. And here's one. In 1994, Congress passed the landmark Violence Against Women Act, recognizing that our laws had not been keeping women safe and taking new steps to protect women. But the Supreme Court ruled the law was not allowed by Congress's constitutional power to regulate commerce, even though violence against women has enormous impacts on our economy. So a woman who was raped, and everyone agreed that it had happened, and everyone knew who did it, she could not sue to recover damages for what she went through. She was not protected by our Constitution. Or take the even more horrific example, female genital mutilation. As barbaric as it is, up to 100,000 girls are potentially subject to this practice in America. Congress passed a law making it illegal, but a federal court in Michigan overruled it, and the current Department of Justice has failed to appeal it, apparently believing it was not Congress's place to protect American women and girls. Our rights cannot be subjected to the political whims of legislators, judges, or occupants of the White House. Our equality is inherent and must be guaranteed. Women are long past due equal treatment under the law, and we will not be satisfied until it is guaranteed in stone. The drumbeat for the Equal Rights Amendment has never been louder. Since 2017, millions of women around the country are marching. 2 more states, Nevada and Illinois, ratified the ERA. The Me Too and Time's Up movements have shined a light on the discrimination that persists in this country, and more than 100 women were elected to Congress. Women are not waiting anymore. We demand what is right, full equality now. We demand that it be spelled out in the Constitution, and you know how to spell it, ERA, now. All right, thank you, and I yield back. And thank you for this extraordinary historic opportunity to address the Judiciary Committee, especially since you have so much more to do.
Thank you so much to each of our Congresswomen. We thank you for your work and thank you for being our first panel. We will now have our second panel come up and be introduced. Thank you. Our first witness will be Ms. Kathleen Sullivan. Ms. Sullivan is a partner in the New York office of Quinn, Emanuel, Urquhart, and Sullivan, LLP. Previously served as Dean of the Stanford Law School, and she taught constitutional law at both Stanford and Harvard. She has argued 11 times before the Supreme Court and is the author of a scholarly article about women's equality. She received her JD from Harvard, her BA from Cornell, and a BA from Oxford, where she was a Marshall Scholar, served as a law clerk for the Honorable James Oakes of the Court of Appeals for the Second Circuit. And Ms. Sullivan, Dean Sullivan, you're recognized for 5 minutes.
Thank you, Chairman Nadler, Chairman Cohen, Ranking Member Johnson. Thank you for the honor of allowing me to testify today in support of the Equal Rights Amendment. Thank you. Chairman Nadler, Chairman Cohen, Ranking Member Johnson, thank you so much for the honor of allowing me to testify today in support of the Equal Rights Amendment, which would add to our Constitution the guarantee that equality of rights under the law shall not be denied or abridged by the United States or any state on account of sex. It would also provide that Congress has the power to enforce the amendment by appropriate legislation. As noted by Congresswoman Maloney and Congresswoman Spear in their eloquent remarks, the United States Constitution, the world's oldest written constitution, is also the only major written constitution in the world that lacks a provision declaring that men and women are equal. And now is the chance to correct that omission, that stain, that embarrassment about our Constitution through the ratification by just one more state of the 1972 amendment. Just to give some examples, the French Constitution provides that the law guarantees to the woman in all spheres rights equal to those of men. The German Constitution provides that men and women have equal rights and that nobody shall be prejudiced or favored because of their sex. The Constitution of India provides that the state shall not discriminate against any citizen on grounds of sex, and every written constitution promulgated since World War II contains a sex equality provision, but not ours. Given the vital role the U.S. Constitution has played in inspiring and informing the written constitutions of other nations, this is a situation that cries out for correction. Now, you might ask, why do we need an Equal Rights Amendment when the United States Supreme Court has interpreted the Equal Protection Clause, passed in the aftermath of the Civil War and erasing the stain of slavery from our existence and declaring equal protection above all for purposes of preventing race discrimination? Why is it not enough that sex discrimination has been shoehorned into the Equal Protection Clause through judicial interpretation? And make no mistake, the decisions that were brought about in the United States Supreme Court through the brilliant advocacy of Ruth Bader Ginsburg as a young woman working together with other women and men to bring about those interpretations, make no mistake that those decisions were momentous and important. But they are no substitute for having an Equal Rights Amendment in the Constitution. The decisions of the Supreme Court do not have the strength, the endurance, or the efficacy of an express constitutional amendment. They are the product of transient and shifting judicial majorities. We, the people, speak through our Constitution with more permanence than any court majority through its decisions. As we made clear when 4 times in our history we passed amendments overruling decisions of the Supreme Court. This nation should proclaim fidelity to the foundational principle of sex equality that will endure for the ages to come and not turn on the vicissitudes of Supreme Court appointments. Finally, I'd like to make the point that this Congress absolutely has the power to clear away any impediment that the deadline imposed back in the 1970s might be thought to impose to ratification by just one more state. And here's why. And I want to adhere to 3 very conservative principles of constitutional interpretation in making this argument: textualism, originalism, and federalism. First, the text of Article 5 provides that the Congress, whenever 2/3 of both houses shall deem it necessary, shall propose amendments to this Constitution, which shall be valid to all intents and purposes as part of this Constitution when ratified by the legislatures of 3/4 of the several states. Article 5, the text, places no time limits on the state's ratification process. Nothing in Article 5 says that ratification must be synchronous, contemporaneous, or bounded within any particular time frame. To the contrary, Article 5 says valid when ratified, and that is the end of the matter. Second, our history confirms as much. The 27th Amendment, which prevents congressional pay raises until an intervening election of the House, was proposed by James Madison and the first Congress back in 1789, and yet it became our law when the 38th state ratified it in 1982. No one questions that the 27th Amendment is an amendment to our Constitution, and what's good enough for James Madison is good enough for the women of America. Finally, in addition to the text and history, our constitutional structure supports the idea that Congress can remove any impediment to the state's ratification when the 38th state decides to join. The framers split the atom of sovereignty in 2. The states have independent powers. Article 5 gives the states the powers to ratify, and consistent with the structural principle of federalism, Congress should view itself as lacking the constitutional authority to fetter the ratification process of the states, and certainly as having the authority to lift its own self-imposed deadlines. For those reasons, I respectfully urge that H.J. Resolution 38, proposed by Congresswoman Speier, is proper, constitutional, and merits swift markup and adoption by the House. Thank you very much.
Thank you so much. Our next witness is Elizabeth Foley. She's a professor of law at Florida International University, where she teaches con law, civil procedure, and healthcare law. She's also of counsel in the Washington, D.C. office of Baker Hostetler, and she practices constitutional litigation there. She previously taught at Michigan State University College of Law, received her J.D. summa cum laude from the University of Tennessee College of Law, where she was an article editor of the Tennessee Law Review and was a valedictorian of her class. Why didn't you come and intern for me? She has a BA in history from Emory University and an LLM from Harvard. She also served as law clerk to the Honorable Carolyn King of the U.S. Court of Appeals for the Fifth Circuit. Professor Foley, you're welcomed as a volunteer.
Thank you so much, Mr. Chairman. Chairman Cohen, Chairman Nadler, Ranking Member Johnson, thank you for inviting my testimony. I think it's an important issue. As somebody who's taught constitutional law and practiced in the field for about 25 years, I'm going to focus on what I think are important procedural aspects to the constitutional amendment process. I'm not going to opine on the merits of the ERA. I'm a woman, and I don't have any particular expertise on that matter, and you have probably better witnesses who can do so. We have 27 constitutional amendments, as everyone knows. The longest one for ratification was, other than the 27th Amendment, which I'll talk about in just a second, was the 22nd Amendment, which deals with presidential term limits. That amendment, the 22nd Amendment, took a whopping 3 years and 340 days for ratification. The Madison Amendment, the 27th Amendment, is an outlier, and it was one of James Madison's original 12 proposed articles to the first Congress. 10 of them made it out as the Bill of Rights. The Madison Amendment was ratified in 1992. It took 203 years to ratify it. But that was only possible because, in keeping with Congress's tradition, at least until the 18th Amendment in 1917, the Madison Amendment, like all of the amendments until the 18th, contained absolutely no express ratification deadline. So its use as some sort of precedent for the ratification of the ERA today, the original 1972 ERA, which was proposed out of Congress, is limited to none. Congress did have a 7-year express ratification deadline for the ERA that was proposed in 1972. And in fact, some people think that, well, you know, maybe it's because the ERA's 7-year ratification deadline is contained in its preamble rather than its text, that has some sort of legal significance. I see absolutely no basis for that argument. In fact, that argument was made in a case called Idaho versus Freeman, which was decided by the Federal District Court in Idaho in 1981. And was roundly rejected. And I'm not here to argue that Freeman has itself presidential value because it was vacated by the Supreme Court because its challenge to the 3-year extension to the ER ratification became moot by the time the Supreme Court got the case, and therefore the Supreme Court decided to vacate that district court opinion. However, the rationale, the analytical framework used by the district court in Freeman, I think, is a good one. And I think any court that was asked to decide the issue today would decide it the same way. And let me explain why. The district court in Freeman hung its hat essentially on a 1921 decision of the Supreme Court called Dillon versus Gloss. Dillon versus Gloss was a unanimous Supreme Court decision, and it's still good today. The Dillon court basically dealt with the 18th Amendment, the Prohibition Amendment. Mr. Dillon was convicted under a federal prohibition law, and he said, well, you can't convict me under that law because the 18th Amendment itself is unconstitutional. He said the 18th Amendment is unconstitutional because it has a ratification deadline. Again, it was the first one to have one. He said, you can't do that. Congress can't impose a 7-year ratification deadline, and it did, and therefore the Constitution is null and void. The Supreme Court unanimously said, no, it's not. Supreme Court said, certainly Congress has the power to impose a ratification deadline if it wants to. Specifically, the Supreme Court in Dillon said that Congress's power to impose a ratification deadline derives from its Article 5 power to propose a mode of ratification. And because this is part of Congress's Article 5 power to propose constitutional amendments and not Congress's Article 1 power, which is ordinary legislation, the reasonable implication from that Dillon rationale is that if Congress imposes a ratification deadline, that ratification deadline is a part of the mode of the ratification, and it must be passed pursuant to Article 5 by 2/3 supermajorities and not simple majorities, as is ordinary legislation. For this reason, when the 95th Congress purported to extend the ER ratification deadline by an additional 3 years, it was likely unconstitutional because it was passed by a simple majoritarian joint resolution of both chambers of Congress and signed, by the way, by President Carter. So any attempted third bite at the apple extending the ERA's ratification deadline yet again would likely be unconstitutional. And finally, in closing, it's notable that there's been no constitutional amendment that has ever been ratified outside of Congress's original express ratification deadline, and there have been 8 of those amendments, by the way. The ERA would be the first. If it is ratified under another majoritarian congressional extension, the amendment would be birthed under a shadow of constitutional illegitimacy. And frankly, that's not good for those who support gender equality or seek societal consensus on that particular effort. Indeed, if broad societal consensus exists for the ERA, why not start fresh? And then there could be no doubt. Thank you.
Senator Pat Spearman, who represents North Las Vegas in the Nevada Senate, to which she was first elected in 2012. She currently serves as co-majority whip. In 2017, Senator Spearman led the revived effort to ratify the Equal Rights Amendment, with Nevada becoming the first state in 35 years to ratify the amendment. She received her Master of Divinity degree from the Seminary of the Southwest and her BA from Norfolk State University, Norfolk. Senator Spearman, you're recognized for 5 minutes.
Thank you, and good morning, Chairman Nadler and Chairman Coleman, Ranking Member Johnson. For the record, I'm Pat Spearman. I represent Senate District 1 in the great state of Nevada. It's an honor to be here today to discuss the Equal Rights Amendment. On March 22nd, 2017, 45 years after the ERA was submitted to Congress, Nevada became the first state to ratify the ERA after the expiration of the June 30th deadline. The state of Illinois followed with ratification on May the 30th. It was my great privilege to sponsor Senate Joint Resolution 2, which supported Nevada's ratification in 2017. When this resolution was discussed, one of the questions always asked, is the ERA necessary? And I continue to see evidence of the need for the ERA every day. In a 1997 article in the William and Mary Journal of Women and Law, they concluded that the need for a federal equal rights amendment remains as compelling today as it was in 1978, when the now Supreme Court Justice Ruth Bader Ginsburg wrote in the Harvard Women's Law Journal, with the Equal Rights Amendment, we may expect Congress and the state legislators to undertake in earnest, systematically, and pervasively the law revised, so long deferred. And in the event of legislative default, the courts will have an unassailable basis to apply the bedrock principle, all men and women are created equal. Pay equity, or maybe I should say pay inequity, is still a significant concern. Although the gender pay gap is narrowing, according to the Pew Research Center, women in the United States earn just 80% of what their male counterparts earn. Women of color, Black women typically, make only 60%, and Latinas make only 50% of what white, non-Hispanic male counterparts make. A common theme of workforce issues for women is the lack of paid leave and affordable child care. In Nevada, the legislature is currently considering a measure that would require a private employer with 50 or more employees to provide paid leave to each employee. Just last week, the Nevada Senate passed Senate Bill 166 to ensure equal pay for equal work and penalize employers who practice pay discrimination. The Nevada Assembly will hear the bill soon, and I anticipate the bill will pass as well. Governor Sisolak said in his State of the State address he intends to make pay equity the law in Nevada, and our state will have a pay equity law. Moreover, when it comes to crimes against women, we continue to suffer from victim blaming, such as shame, stigma, and the ingraining of guilt upon the female victim. The Civil Rights Act of 1964 prohibits employment discrimination based on race, sex, color, national origin, or religion. But sexual harassment became codified in U.S. law based upon sexual harassment cases in 1970s and the 1980s. The EEOC saw 13% increase of workers alleging sexual harassment from fiscal year 2017 to fiscal year 2018. To begin the journey of addressing sexual discrimination and harassment in Nevada, we now have a governor's task force on sexual harassment, discrimination, law, and policy to reduce harassment in the executive branch. February 4th, 2019, the Nevada legislature became the first female-majority legislature in the country. Women now hold 51% of the 63 legislative seats, and nationally, the number of legislative seats also increased. We celebrate the fact that Congress has 23% more women, but the struggle continues and the work is not done. Mr. Chair and members of the subcommittee, when the ERA was first gained popularity in the late 1960s and 1970s, it was heard as a clarion call for change, just as the change continues for racial equality, fairness, and justice, some 154 years after adoption of the 13th Amendment. The work for change today has become a clarion call to act responsibly in a manner that ensures equity for all of its citizens. Mr. Chairman, and members of the subcommittee, I'm before you today because I believe from the bottom of my heart in the foundations of the ERA for all people. In restricting the time limit for ratification of the ERA, it can be found in the resolving clause, as you have already heard. But now is the time to show the global neighborhood that we as Americans, to show the global neighborhood that when it comes to equality, we lead for all. Equality for justice has never been given. Never. Each generation has always had to fight for the equal justice and the equal rights that they so deserve. Vietnam veterans persisted to get health care recognition. HIV/AIDS persisted to ensure their human dignity, and members of the LGBTQ community persisted to gain marriage equality. Persistence, faith, and hope fuel the indomitable spirit of this movement, and we must honor the sacrifices of our mothers and our grandmothers. We must commit to the preservation of justice and equality for our posterity. Mr. Chairman and members of the subcommittee, we got tired, but we did not faint. We became weary, but we did not stop. History demands that we take a stand on this most important journey toward full equality. We stand on the right side of history. We must persist in the name of all that is good. The road is long and it has been full of twists and turns, but we must continue to get the Equal Rights Amendment as part of our Constitution. Thank you for your time and attention.
Thank you, Senator. Cool, can't do that, Finally, Patricia Arquette is an Academy Award-winning actress with a long and distinguished acting career dating back to the 1980s, also one of Hollywood's leading advocates for the Equal Rights Amendment, and a passionate activist for women's equality. I believe you might have even mentioned the ERA when you received an award sometime in the past. That's pretty strong. You're recognized for 5 minutes.
Thank you, Chairman. Thank you, Chairman Nadler, Chairman Cohen, Ranking Members Johnson and Collins, and Congresswomen Spear and Maloney for your tireless work on the ERA, and to the members of the committee. I come here not as a constitutional lawyer, but as a citizen, as an American woman, to advocate for what I feel is critical for our country. I come with the goodwill and the faith that when we examine the reality of women in America today and remember the historic injustices women have faced in our country, we will all feel compelled to do what we must to ensure that women are afforded every legal right and equal protection in our country. Women have waited 232 years to be enshrined as full and equal citizens. Why? Because in 1787, women were left out of the Constitution intentionally. While the Constitution says nothing about deadlines for amendments, Congress put a deadline on the Equal Rights Amendment when it was passed in 1972. I am here to appeal to you to remove the 1982 deadline placed on Congress for the ratification of the ERA. Just because women didn't achieve full equality in America by 1978 or by 1982 doesn't mean they shouldn't have it today. There's a groundswell in this country. Women are being elected in record numbers. Women are rising up by the millions and saying they will not be sexually assaulted. They will not be paid less. They will not be treated as subhuman, and they will have their voices heard. Some people think women do have constitutional protections because of the 14th Amendment. But when asked about this, Supreme Court Justice Antonin Scalia said, certainly the Constitution doesn't require discrimination on the basis of sex. The question is whether it prohibits it. It doesn't. So a recent Supreme Court justice interpreted the Constitution as saying it did not prohibit discrimination on the basis of sex. So whether you agree with him or not, the fact remains, this is how a recent Supreme Court justice interpreted women's rights in our Constitution. And this is why we need to amend the Constitution and leave no room to question if women have full constitutional equality, because women's protections cannot be left to interpretation alone. So let's look at the treatment of women in America today. These are present-day truths. These are not antiquated horrors we have to search for in history books. These are things that are happening to both Democratic and Republican women. In America, in 2019, there are estimated to be hundreds of thousands of untested evidentiary rape kits across the nation. Only half our states mandate the timely testing of evidence contained in these rape kits. Many victims are being billed for the collection of their own forensic evidence. Countless emergency rooms and hospitals don't even have trained staff to collect evidence in rape kits, even though it's estimated that 1/4 of all women in America will be raped in their lifetime. In some states in America today, women can be forced to co-parent with their convicted rapists. And incarcerated women, up until 3 months ago, could be forced to give birth while shackled to beds. We have the only rising mortality rate in the developed world. American women, especially African American, Latina, and Native American women, are dying of pregnancy-related complications here on the wealthiest nation on earth. And we know the gender pay gap is having devastating consequences for women and their families, especially women of color. We know 98% of all jobs, women are paid less. According to the Census Bureau, 4 million women over 65 years old are living in poverty. But if they had equal pay, more than 2.5 million children with working single mothers would be lifted out of poverty. These are just a few examples of how systemic bias against women is expressed in America. Why? Because women don't have the same value as men in our country. That was true in 1787. It was true in 1982. It is true in 2019. So I hope by now we are all ready to make women's equality a bedrock American value and enshrine it in the U.S. Constitution. I hope we're ready for all our mothers, daughters, sisters, and friends to have full equal rights. Why didn't women achieve full constitutional equality in 1787 or 1982? Because the country wasn't ready? Well, I hope you're ready now, because women have been waiting 232 years for equality in this country, and it's failed them. Legislators have blocked the passage of the Equal Rights Amendment for decades, but we're done waiting. Thank you.
Thank you very much, Ms. Arquette. We will now proceed under the 5-minute rules which we have for asking questions, and each member of the panel will be questioned. I'd first like to start with Ms. Arquette. You're a star, famous, celebrated, and yet in your career, I'm sure you face some type of sexism, the same that ordinary women face every day. What are some of the gender-based obstacles that you've had to face in your own career?
I've been sexually assaulted. I've had to turn down work because I had employers that were not willing to be reasonable as people. They wanted me to sign papers saying I'd be naked and do whatever they wanted. I'm an actor. I'm dealing with the director. I have no say as an employee or as a citizen, as a human being. I've called the police when I was sexually assaulted by a stranger on the road and had the police not even come. And I was a kid. I've had so many experiences in this country of sexual assault, but it's not really just about me. woman after woman. Okay, listen, don't we all expect when 1/4 of all women will be raped in their lifetime, isn't it reasonable to expect that an emergency room would know how to collect evidence from a rape kit? Isn't that reasonable? And yet women are going, when they've been raped, from hospital to hospital and being told, sometimes they go to 4 hospitals right after they've been raped, and they're told they don't know how to collect the evidence. They have to go to another place. By the time they get their rape kit taken, and this is from a joyful heart, gave me this information, by the time they get their rape kit taken, the date rape drug is gone. It is no longer in their system. And we know only 3% of rapists ever spend a day in jail. This is systemic. This is across our country. We need every tool to root out bias, both racial bias that women of color are experiencing, and also we have to root out sexist bias. Look, we have women also in Alabama who are dying of treatable cervical cancer because they are poor Black women. There's 1 gynecologist for 5 counties. We have African American women dying. We're the only country with a rising maternal death rate in the developing world. And 700 Black women died. What is going on? What is happening here? These are preventable things, but time after time we're seeing all these layers of bias, and until we have the Equal Rights Amendment, and with all of these other Title IX and all of these things, we'll never be able to root out this, and we'll never be able to change this for American women.
Thank you so much. Ms. Sullivan, let me ask you some rapid fire because you do have time. Some opponents of the ERA have argued it would have a terrible effect, like eliminating women's sports teams or abolishing separate bathrooms. Can you tell me what your thoughts are on those arguments?
The ERA would have no such effect. We have had interpretation of the Equal Protection Clause that allows the unequal treatment of men and women when it's important to rectify past disadvantage, for example. And we've had ERAs in 22 states, adopted by 22 states, and we haven't seen the elimination of same-sex sports teams or same-sex bathrooms in any of those states. So that's a myth.
Thank you. Professor Foley has argued that the states which have rescinded their ratification should not be counted in the assessment of whether we've reached the 38-state limit. In your view, should states be able to rescind their ratification?
In my view, they should not. Article 5 provides for ratification. It does not provide for rescission, and we have never recognized a state rescission of its prior vote for an amendment. In fact, the 14th Amendment that contains the Equal Protection Clause was ratified even though Ohio and New York had purported to rescind their votes for it. That creates powerful precedent that rescissions are null and void, and that's what the Attorney General of 5 states told the states who tried to rescind after the 1972 passage of the ERA. Rescissions do not count. Once ratified, it's a one-way ratchet.
And some Republicans have brought up the issue of abortion or a woman's right to choose. You mentioned all the industrialized nations in the world have amendments on ERA. How have they affected in their countries and just in general, can you discuss what effect ERA would have on reproductive rights?
The ERA is a totally separate issue from abortion and reproductive rights. It will help encourage the equality of women, which does involve reproductive rights. But in those countries with the ERAs and in those states with ERAs, the passage of the ERA has not changed the law of abortion in those countries. The Supreme Court has already protected the right of access to abortion as a matter of reproductive choice, just like it protects other intimate choices, like the choice to use birth control. And that debate has happened without the ERA. So the ERA is about equality, and any debate about abortion and reproductive rights will continue after its passage, as it has in other states and other countries that have adopted it.
Thank you. And now I'd just like to go to Professor Foley for a little history lesson. I'm sure as a University of Tennessee law student, you learned about the Perfect 36 in Tennessee and the ratification of the women's right to vote.
Yeah.
Can you tell us the story about Harry Byrne, a Republican legislator? Do you know that story?
No, I don't.
Well, you should.
Okay.
So should everybody else in America. It came down in 1920. 35 states had passed, ratified. 12 had said no. 1 state left, Tennessee. Major battle. Senate, which I was a member, not at the time, but for 24 years, passed it like 25-7. The House was tied. It was almost the last day. A Republican male, young man named Harry Byrne, got a note from his mother. Harry, do the right thing. And Harry did the right thing, and Harry Byrne, a Republican, voted yes, passed the amendment, the perfect 36, and women have the right to vote. Thank you very much, Harry Byrne. I now recognize Mr. Johnson, who walks in Harry Byrne's shoes.
And my mother would have given me the same advice, and I would have voted for it. First, regarding Ms. Sullivan and my colleague Representative Maloney's bold contention that the ARA, quote, has nothing to do with abortion and that my saying so is divisive, I respectfully present to you all, and will ask consent to include in the record of this hearing these documents, that show that pro-abortion groups are clearly saying now that adopting the ERA would mean the end of laws that protect the sanctity of every human life. And I'll give you 3 examples in a new article published by the National Organization for Women entitled, "Is the Equal Rights Amendment Relevant in the 21st Century?" Abortion is discussed on pages 3, 4, 5, and 6. And they say, quote, "An ERA properly interpreted would negate the hundreds of laws that have been passed restricting access to abortion care and contraception. Denial of legal and appropriate medical care for women, and only women, is sex discrimination, and a powerful ERA should recognize and prohibit that most harmful of discriminatory actions," unquote. Consider a January 2019 complaint by the Women's Law Project and Planned Parenthood and Allegheny Reproductive Health Center v. Pennsylvania Department of Health and Human Services. It's a lawsuit that argues the state ban on government-funded elective abortions violates the state's ERA, and that any denial of this claim, including past Supreme Court construction, quote, "is contrary to a modern understanding of the ERA." Look, the fact is that now there's essential agreement between pro-life and pro-abortion groups that the language of the 1972 ERA is likely to result in powerful reinforcement and expansion of abortion rights. NARAL Pro-Choice America, in a March 13, 2019 national alert, this is last month, asserted that, quote, "the ERA would reinforce the constitutional right to abortion and it would require judges to strike down anti-abortion laws," unquote. So I would just say respectfully, all these groups are not being divisive. They are simply acknowledging the facts. Here's my questions real quick for Professor Foley. President Jimmy Carter wrote to the House Judiciary Chairman Peter Rodino on July 12, 1978, and he stated, and I quote, "I am hopeful that ERA will be ratified before the present deadline expires," unquote. That original expiration date, as we've all heard, was March 22nd, 1979. Indeed, the ERA proponents knew that they could not secure ratifications from 38 states by March 22nd, 1979, so they lobbied Congress one more time, which resulted in the congressional majority vote for a 39-month extension. But even that deadline wasn't met. And on November 16, 1983, the New York Times matter-of-factly reported that the ERA, and I quote, "went through laborious debates in the legislatures of all 50 states. That proposal died when its time limit for ratification expired in June 1982, still 3 states short of the necessary approval of 38 legislatures," unquote. Congressional Quarterly reported the proposed Equal Rights Amendment to the Constitution officially died June 30th, 1982, 3 states short of the 38 needed to ratify it. Here's the question. Have there been any developments since 1982 that would render any of those contemporaneous statements of the ERA's expiration somehow inaccurate?
Short answer, no. Longer answer, the point from Supreme Court precedent, I think, to keep in mind procedurally about constitutional amendments is that you're in charge, right? Congress is in charge, and you're in charge because of Article 5, not because of Article 1. And so what that means is that you don't have to impose a ratification deadline if you don't want to. But if you do, it sticks, and it's justiciable. And so the problem with the ERA is that you put a 7-year deadline in there, and to change that would require a new proposal with supermajorities of both houses of Congress. So as much as you may want the ERA to pass, I don't think you have the constitutional authority to do so, any more than you could, for example, pass a proposed amendment without a constitutional ratification deadline and then decide a few years later to suddenly impose a ratification deadline right before the requisite number of states had ratified, the 3/4 had been, threshold had been satisfied, in order to stop the ratification. I don't think you can go in either direction, and I think that's what the courts would hold.
I so appreciate you pointing out the distinction between Article 5 and Article 1, because I think there's a lot of misunderstanding about where this power, from where it derives, and that this has never happened before where an amendment was adopted past its deadline. That's really important for you to point it out. I appreciate that. Another quick question. Some claim the ERA has wide popular support, but if that were so, Why is there a reluctance on the part of the majority of this Congress to simply reissue the ERA to the states without any ratification deadline, do you think? And what does that reluctance say about the actual prospects of popular support for the ERA?
Well, it's a great question. I think that it's just easier, right, to just go with a three-state strategy and see if it sticks after years and years of litigation. I don't think it will stick, so I think, unfortunately, it would actually set back the clock for those who support gender equality. I think, it would make things worse. If you really want to do this, the right way to do it is clear. It is to go ahead and repropose by 2/3 of both houses of Congress and submit it to the states for 3/4 ratification. Now, if you can't get the 2/3 from both houses of Congress today, well, that may reflect the political reality of today. But that is why there is a supermajority threshold for the proposal of constitutional amendments. They require supermajorities. They require societal consensus. One of the reasons why we may not have societal consensus today in 2019 when we had it in 1972 is that things have changed. In 1972, for example, that was 1 year before the Supreme Court decided Roe versus Wade. The Supreme Court had not firmly entrenched its equal protection analysis. I believe the big case really was the VMI case in 1996, penned by Ginsburg, where she basically imposed an intermediate standard of review for gender-based classifications under the Equal Protection Clause. That means that all gender-based classifications, state-based classifications, receive a presumption of unconstitutionality today. We didn't have that back in 1972. So I think the fact that the Supreme Court has changed its equal protection jurisprudence, including recognizing a woman's right to terminate her pregnancy prior to the point of fetal viability, has changed things.
Thank you. I'm out of time. I yield back.
Thank you, Mr. Johnson. I now recognize Mr. Nadler from the vibrant West Side.
Thank you, Mr. Chairman. Professor Sullivan, Professor Foley argues against our right to rescind the ratification deadline, and she quotes the Dillon case, which I would point out is a district court case. It was mooted. It's not a district court case?
Dillon versus Gloss is a Supreme Court case decided in 1921. It's, I believe, Freeman. Idaho versus Freeman is the one you're talking about.
You quote that case, and basically you're saying that you're making the Article 5, Article 1 distinction because Article 5, Congress's power to impose a deadline derives from its power to propose amendments to the Constitution under Article 5. Therefore, to change that, you'd need the same supermajority that you had to start with. It's Article 5, not Article 1. Article 1 is the general legislative powers. So we do not have the ability to extend the ratification deadline except with a 2/3 vote. I'd ask Dr. Sullivan, why is that wrong?
It's wrong, and you absolutely can change the deadline. Am I the only textualist here? I'd like to go back to the text of Article 5.
I'm on record. I'm a textualist.
Justice Scalia is not here.
Yes.
Article 5 does not provide Congress with any power to decide when an amendment has been ratified by the states. It simply says when 3/4 of the states ratify, the amendment is enacted. So it's unclear whether you have the constitutional power as against the authority of the states under Article 5 to tell them when their ratification deadline is up. But if you have that power, you surely have the power to change, alter, rescind, overrule your deadline. And you got that from the Supreme Court in a case that my friend Professor Foley didn't mention, Coleman versus Miller, which involved the Child Labor Act amendment and which said that the issue of whether Congress can control deadlines is a non-justiciable issue within the exclusive and unreviewable authority of Congress. So it's not clear you have the power to set a deadline. It's a 20th century practice. It's not in the framing. It wasn't something James Madison thought we needed, and we didn't need it for his amendment. But if you had the power to set one, you certainly have the power to change it.
So the case law does not firmly establish the right to set a deadline in the first place?
Correct. Well, the case law says that Dillon versus Gloss, to the extent it holds anything clear from my position, Dillon versus Gloss said that when the 38th state ratified, it wasn't 38 then because we didn't have Alaska and Hawaii, when the 3/4 of the states have ratified, it has passed. That's why Dillon had to go to jail for sending a case of wine in San Francisco, because when the 38th state ratified, before Congress ever said whether it was good or not, that prohibition law was enacted. So actually, Dillon versus Gloss stands for the position that the state, when 38 states ratify, we're done, one and done.
Because Congress lacks the power to limit state sovereignty by granted because the states have the power to ratify under the Constitution, and it would be a limitation on state sovereignty to limit their power by a deadline?
That's exactly right, Your Honor. That's a very plausible argument, and usually conservatives like states' rights. I don't know why they don't like states' rights here.
I've observed. I must say, I've observed over the course of a rather lengthy political career that conservatives, and sometimes liberals too, like states' rights when it serves their purposes, and they don't like states' rights.
Blue states' rights.
Doesn't. Well, in any event, so we don't have the power to set that ratification in the first place, but if we did, we'd have the same power from the same source to rescind that ratification.
That's exactly right. You don't really have it through Article 5, because Article 5 doesn't speak to any congressional promulgation. You only have it, if you have it at all, through Article 5 plus the necessary and proper clause of Article 1, Section 8. If you have it under the necessary and proper clause, you certainly have the power to change it.
That's a very powerful argument. Ms. Arquette, thank you for your leadership and activism on the subject. Can you talk about why you think the push to pass the ERA is resonating with so many men and women at this point in American history?
Well, one of the things is, as we've heard earlier, the gender pay gap. And half of the women working in America are the primary breadwinners. We know what the wage impact is, and for Latina women over a lifetime, that's over $1,135,000. For Black women, that's $946,000, and for white women, that's around $400,000. And it doesn't change, actually. Oddly enough, the gender pay gap remains. We have it in every state. We have it in every country on earth, this gender pay gap. And we need every possible way to eradicate that, to look at bias. Some wonderful things have happened recently, that some leaders of industry have come forward and done gender pay gaps to remedy the situation, and they found, yes, there they were. Everything that everyone talked about, it's there. So we need to advance our country, because women are going to retire in poverty. They're twice as likely as men, or one-third more likely than men to retire in poverty. It takes them longer to pay off their houses, their car payments, to put their kids through college. It's really having devastating effects on women.
Thank you very much. My time has expired.
Thank you.
Thank you, sir. And I now recognize the gentleman from Virginia who has so far had outstanding service on this committee, Mr. Klein.
Thank you, Mr. Chairman, and I want to thank the witnesses for being here and for all the attendees who are here, and for Congresswoman Spears and Congresswoman Maloney for all of your work over the years to ensure equality for women. Women deserve to live, work, and thrive in America free from discrimination and inequality. This document, which I carry around with me, is very important to every American and should ensure equal rights for every American. I first want to ask Professor Foley if, in light of the answers that were given, if you have anything else to add briefly.
Yeah, I did. If I could respond about Coleman. I didn't have time to talk about Coleman, but I think it's worth talking about. It was a case that went to the Supreme Court. It was decided in 1939. It involved the Child Labor Amendment, which is one of those amendments that never got ratified. The Child Labor Amendment did not have a ratification deadline, which was typical of its day. So what happened was that Kansas, the state of Kansas, originally rejected it about a year after it was proposed. And then 13 years later, after it was proposed, Kansas changed its mind and ratified it. And so the question before the court, a bunch of Kansas state legislators who were mad that Kansas changed its mind, took the case all the way to the Supreme Court, and they said, you can't do that because, number one, it's an improper ratification because a lieutenant governor broke a tie in the Senate, and that was wrong. And number two, the fact that it was ratified so long after the original proposal, 13 years after the original proposal, means that it was not a valid ratification because it wasn't within a reasonable time of ratification. So the Supreme Court decided in a majority opinion that the issue of the 13 years that it took Kansas to ratify was non-justiciable. And it was non-justiciable because the Congress that proposed the Child Labor Amendment had chosen not to provide a ratification deadline. So think about it, right? You pass a proposed constitutional amendment, you send it to the states. It has no ratification deadline. One of the states, 13 years later, decides to ratify it. They take it to the Supreme Court, and the Supreme Court is asked to decide if the 13 years is too late, right? And the Supreme Court said, no, it's not too late because you didn't provide a ratification deadline. The 13 years versus 20 years versus 203 years, as in the case of the Madison Agreement, that's non-justiciable. We're not going to touch that. But that has nothing to do with the inverse situation where you do provide a ratification deadline and it's not satisfied. So Coleman has no precedential value on that question, which is why I didn't put it in my primary remarks. And I think because Dillon is good law and it is a unanimous decision and it says you are in charge and you can specify a mode of ratification pursuant to your Article 5 authority, that if you do provide a deadline, it has to be adhered to.
Thank you. And I also was reviewing the Supreme Court decision in Dillon v. Gloss, and one of the passages in the decision, I'm quoting, of the power of Congress keeping within reasonable limits to fix a definite period for the ratification, we entertain no doubt. Dr. Sullivan, do you entertain doubt?
Thank you, Congressman. I do have doubt about Dillon versus Gloss. I think it doesn't take into account the federalism revolution we had on the Supreme Court under the leadership of Chief Justice Rehnquist.
Reclaiming my time, don't you agree that that would require an additional decision by the Supreme Court to reverse that decision to allow for it?
Yes, it would, but I don't think Dillon controls you. I think Dillon supports your power to change your procedures.
Correct. And so Congress does have the power to extend a deadline, but that extending some action by Congress would be necessary to give states that extra time. Is that correct?
Well, I don't think it's necessary, but I certainly think it's sufficient, and I think you have the power to do it, notwithstanding Dillon.
So in your mind, that passage of that decision and the deadlines passed by Congress could be ignored by a 38th state in the next year?
I think that's a potential decision that could be found by a Supreme Court in the future, but you don't need to face that because Coleman versus Miller did, as my colleague said, give you unreviewable authority to regulate your own deadline procedures, and I think you can do it by a majority vote. You don't need 2/3.
Professor Foley, you disagree?
Yeah, I do, because the people who cite Coleman versus Miller for this idea that everything Congress does associated with the constitutional amendments is non-justiciable are way overreading Coleman versus Miller. In fact, that position that everything Congress does is non-justiciable when it comes to Article 5 comes from a plurality opinion that was penned by Justice Black. It got 4 votes. That's less than 5. That's not a majority. And in fact, that's the position they took, that everything Congress does when it comes to constitutional amendment is non-justiciable. Now, think about it. 3 members of the majority, there were 7 members of the majority in Coleman, did not sign on to Black's concurrence. See? So there's 3. 2 dissenters ruled that it was justiciable. They wanted to address the issue. So you add 3 plus 2 from Coleman. You actually get 5 justices from Coleman writing a very narrow opinion saying the only thing that was non-justiciable in Coleman was whether Kansas's ratification 13 years after proposal was a reasonable period of time when Congress had not specified a time limit. That's it.
Thank you. My time's expired.
Thank you, Mr. Klein. We now recognize Professor Raskin.
Mr. Chairman, thank you. Thanks to all of our witnesses. So there have been 17 amendments since the Bill of Rights, and the vast majority of them have expanded equality, political participation, and democracy in America. So the 13th Amendment abolished slavery. The 14th Amendment gave us equal protection and due process. The 15th Amendment struck down race discrimination in voting. The 17th Amendment shifted the mode of election of U.S. senators from the legislatures to the people. The 19th Amendment, 99 years ago, gave us women's suffrage. The 23rd Amendment gave people here in D.C. the right to participate in presidential elections. The 24th Amendment abolished poll taxes. in federal elections. The 26th Amendment lowered the voting age. Do you think, maybe start with you, Professor Sullivan, that the Equal Rights Amendment is in the mainstream of the trajectory of American constitutional development?
Absolutely, yes.
And is it something that is kind of frivolous and extra, or is it something that is necessary and central to our development as a country?
Necessary, central, foundational. It's 100 years since we had the 19th Amendment placed in the Constitution. Before that, the Supreme Court had said there is no equal right of women to vote. It's high time, after 100 years, that the 19th Amendment, which was never expanded beyond its voting boundaries, the principle be recognized for all purposes against all public discrimination by passage of the ERA.
Dr. Spearman, why did Nevada, after all of these years, decide that the Equal Rights Amendment was something that it needed to do?
Thank you for that question. Let me start by saying, obviously I'm African American, I'm a woman, I'm a veteran, I'm an ordained minister, and I'm a proud member of the LGBTQ community. The discussion about equality I have been in all of my life, and it's always been contentious. And so for me to carry the ERA and get it passed, get it ratified in 2017, it was simply the right thing to do. Every time we come to equality, we always parse words. Every time we're talking about someone has the same right as someone else, we're not talking about special rights here, we're talking about equal rights. And as I said before, the trajectory is moving in the right direction. And it's moving in the right direction because every time I have been in a discussion about equality, whether it's about racism, whether it's about sexism, whether it's about homophobia, every time we always parse words about whether or not someone has the right to equality. We ratified it because it was the right thing to do.
Thank you. Ms. Arquette, let me come to you. You gave some eloquent testimony about rape kits and discrimination against women in different places. What do you say to those who assert that the Equal Rights Amendment is too far removed from the daily struggles that women have against sexual harassment, against sexual assault, against states failing to deliver the rape kits and so on? Is the ERA something that's actually pie in the sky, that's removed from the daily struggles of women?
Well, I have to say to them that the Equal Rights Amendment, I think, would give us another tool to examine unconscious bias, I think, and sometimes, obvious bias that we know in our country. It's like whack-a-mole, okay? All of a sudden you bash down one thing, like child marriage. The last few years, some very fierce activists across the country have been advocating and working with legislators to change some laws in some states so that we no longer had adult males impregnating girls and marrying them. This is recent. This is very recent, okay, in the United States of America. But it is like whack-a-mole. I just found out, I do women's rights work. This is what I do. I just found out a couple weeks ago that women in most countries, not most countries, most states here in America, when you go to a hospital for your tonsils and you go under, if you're at a teaching hospital, they can bring in medical residents who do internal vaginal exams on you while you're unconscious without your consent. Most states in America. Okay? So I want the Equal Rights Amendment. I want VAWA. I want every protection under the law to start rooting out systemic bias.
And the ERA comes with these other statutory protections as part of a movement for general transformation in the society.
And we need that transformation.
Well, I thank you for your testimony. Professor Foley, let me come to you. You seem to question your last remark, the controlling authority and solidity of Coleman versus Miller, which I always taught as a key precedent for the proposition that the whole constitutional amending process is a political question, is non-justiciable. Do you know of any Supreme Court cases where the Supreme Court has intervened to decide either that either a procedure was unlawful or that a constitutional amendment was unconstitutional?
No, but of course we've never had that opportunity arise. The closest we came was with the 3-year extension of the ERA and that district court decision in Idaho versus Freeman, but because it got mooted, the 3-year deadline expired and no additional states had ratified. We just don't have.
I just want to get the logic of your position. Are you saying that if the deadline were to be extended, that this should be the first constitutional amendment in our history to be struck down as unconstitutional?
Yeah, I think it could be.
But you think it should be?
That's a different question, isn't it?
That's the one I'm asking, yes.
Well, I mean, I'm not a policy person, and I'm not here as someone to talk about whether the ERA is a good idea or a bad idea.
I thought it was a
We can opine about
constitutional
that.
question. In other words,
No.
I thought you were
Oh,
opining.
I thought you were asking me, like, should it because it's a great idea?
I'm sorry?
I thought you were asking me, should it be struck down because ERA is a great idea?
You seem to be invoking some of the Supreme Court justices who did not think that these were non-justiciable political questions. And I guess what I'm asking you is, are you saying that the Supreme Court, in the event that we were to extend the deadline, should intervene to strike it down, or if states were to adopt the Equal Rights Amendment, to say that it is not a constitutional amendment and it's not part of the Constitution?
Yes, I think that when it gets litigated, if you decide to extend the ratification deadline, or if it just gets ratified, you know, again by one more state, it will be struck down as an unconstitutional amendment process. So yes.
Thank you for clarifying that.
Scanlon from Pennsylvania, one of the great new women members to our Congress. Welcome.
Thank you so much. I am so excited to be here. I mean, this is one of those aha moments for a new member in Congress. I want to show you this. It's a book called Girls Are Equal Too by Dale Carson. My mother gave me this book over 40 years ago because she wanted me to think about gender roles and how they impacted even preteens like myself at the time. And for that, having just joined the most diverse Congress in history, I'm extremely grateful. I also want to share with you this pin that I'm wearing. I wore it to the State of the Union earlier this year. It's a pin that was given to Alice Paul and other women who had chained themselves to the White House fence demanding the right to vote. It represents a jailhouse door. It was given to them when they were released from jail after a series of hunger strikes, et cetera, and after they won the right to vote. Now, Alice Paul, of course, wrote the Equal Rights Amendment, first introduced in 1923, nearly a century ago. She also happens to have earned her bachelor's degree from Swarthmore College, which is in my district. So I'm extremely proud of that connection to Alice Paul and looking forward to carrying forward her work in this Congress. I'd like to kind of pull back a little bit and maybe talk about the impact of the ERA, the potential impact of the ERA on girls, the girls of today. Ms. Sullivan, could you speak a little bit to the fact you noted in your testimony that every other major democracy with a written constitution guarantees equal rights for men and women? What effect do you think the U.S.'s outlier status has on the U.S. on the world stage and the impact on the young women of today who are going to be our leaders in the future?
Well, thank you. I think the fact that we don't have a provision for sex equality is shocking in 2019, and it's shocking comparatively when we look at the rest of the world. All of the rest of the industrial democracies of the world, every nation that adopted a written constitution, many of them based on ours in the aftermath of World War II, they all have sex equality provisions. Why don't we? And it speaks very loudly. The title of your book is wonderful. Your mother's advice was wonderful. The Constitution speaks to our most basic commitments. It says out loud, in the one voice we have as we the people, who is included as equal among the people. And the absence of a statement that women are the equal of men in our Constitution is something that's unfathomable and something that should be fixed.
Thank you. Ms. Arquette, when you won the Academy Award not so long ago, you gave a very powerful acceptance speech about the need to address pay inequality for women in the U.S. and the need for the Equal Rights Amendment. Have you seen any real-world effects as a result of that speech?
Thank you for that question. Yes, I have seen some real-world effects. I recognized a problem. I was winning this award for a woman who was struggling to feed her 2 kids as the primary caretaker and breadwinner. And so I gave this speech, and people started to talk about it. One thing that happened was Cindy Robbins and Layla Seika at Salesforce went in the next morning to their boss, Mark Benioff, and they said, "Hey, are we being paid the same?" And he said, "Yeah, I'm sure we are. You guys are." And they said, "Are you sure you're sure?" And he said, "Well, I think we are. Let's do a gender audit." And what they found was No, turned out they were paying, mostly women, $2 million less every year. Now compound that, if that's your salary, and you're having this huge chunk of money kept out. So they remediated that. They fixed that for all of their employees. And then the next year they did a gender wage race also. They added race in and they found again they had another gap. And they fixed that. Then Mark Benioff went out to the head of Apple, Intel, The Gap. All these people signed on. They started doing gender audits and they started paying people fairly. But not only that, Senator Hannah Beth Jackson of California saw it. She said 2 days later, she presented her equal pay bill on the floor. It passed. She'd been trying to pass it for 36 years. And since then, 41 states have passed equal pay bills. People have come up to me and they said, thank you, my boss gave me a check for thousands of dollars. I can't believe it. What I'm talking about is magic. When you make the intention, when you say to the world, women are equal in America, the system has never corrected itself, call it out. It will start to correct itself. It will start to fix things we've been having to deal with since the beginning of our country.
Thank you.
Thank you, Ms. Scanlon, and I now recognize a member from Pennsylvania who's also a great new woman member, Ms. Dean.
Thank you, Mr. Chairman, and thank you for holding this historic hearing. Like my colleague, Representative Scanlon, I come from Pennsylvania where we had no women in Congress as of the last Congress, and we now have 4 women in Congress. So good things can happen in Pennsylvania and elsewhere. And like my friend, Representative Scanlon, I too feel like we are at an extraordinary moment. I can't believe I have the privilege of sitting here and raising again the ERA and the valuable requirement and need to do it. But that is met by also a paradoxical moment. How in God's name have we not done this yet? And why would anyone want to stand in the way? So floating in my head is, what is anybody afraid of? What is there to be fearful of if we make this enshrined in our Constitution that women hold the same right? And I was thinking about this as a mother. I'm a mother to 3 grown white men. I don't worry about whether they're going to be treated equally. I have that privilege, but I have a 7-year-old granddaughter, and I absolutely worry if she will see that everything is open to her, that she is equal under the law and protected under the law. And so, Ms. Sullivan, I wanted to go back to you. I'm thinking about why are we here? Why can't we just get this done? Back to the notion of symbolic or necessary. A lot of people just say, oh my gosh, it's just a symbol. Oh my gosh, I can't believe you're still arguing about ERA. Can you go again about the essential nature of this?
It's necessary, it's essential, and it's not just symbolic, but let me say symbols are important. Our
Yes.
Constitution is a very important symbolic commitment to equality that speaks volumes. As Patricia Arquette says, it has a trickle-down effect into the rest of the private sector as well when we declare our public equality. But why it's needed is we never have had sex discrimination treated the same as other forms of discrimination. Under interpretations of equal protection, it might be allowed in ways that the ERA would help to cement. Second reason why it's necessary, and I want to focus on you, the Congress, Section 2 of the Equal Rights Amendment gives to you, the Congress, the power to enforce the amendment by appropriate legislation. Up till now, the Supreme Court has interpreted your power under the Enforcement Clause of the 14th Amendment and under the Commerce Clause to be quite limited in addressing sexual assault, sexual violence, and other unequal treatment of women. You would gain power to once and for all help to rectify patterns of discrimination that the states have failed to rectify. And that's a very important, and I would argue, essential aspect of the ERA.
Thank you. And on the issue of, this will just grant unfettered rights to abortion, I think it's obviously a specious argument, a false argument. But I do come from the experience of being 6.5 years a state legislator in the Pennsylvania House. So I'd like to flip that abortion argument on its head and say, wouldn't the ERA actually help us? Wouldn't it actually tamp down the false, lousy legislative proposals that we see session after session in many of our state legislatures that are clearly anti-abortion, they're clearly unconstitutional, but we face them every single year. Isn't it possible if we enshrined in our Constitution equal rights, then those equal rights under the law, including Roe v. Wade and others, would be further protected, not expanded, protected?
Are you directing that to?
Yes, I'm sorry, Ms. Sullivan. Yes, thank you.
Yes, the equality of men and women, reproductive rights are a very important aspect of the equality of men and women. People feel divided about abortion in this country because people of goodwill on both sides have passionate commitments about the difficulty of the decision, and no woman who ever has an abortion treats it as anything other than a difficult decision. Right. But the ERA would enshrine the principle of equality. It would leave for another day the interpretation of whether some limits might be allowed as they are now, or whether some limits go too far and impose an undue burden as we have now. I do think that it distracts from the debate about equality to try to make those debates the focus of our attention now. It won't be activists in pamphlets or lawsuits who determine the meaning of the Equal Rights Amendment. It will be the Supreme Court, and the Supreme Court has had a balanced approach till to date. Conservative justices reaffirmed Roe v. Wade, the core of Roe v. Wade, when they sat on the court, and will continue to have that debate, but it is no reason not to adopt the ERA now.
Thank you, Mr. Chairman. I thank all the testifiers for coming before us.
And I thank the two ladies from Pennsylvania who stayed within their time limit, showing great restraint. And now I recognize the two great ladies from Texas, starting with Ms. Garcia. Oh, I'm sorry. Excuse me. Mr. Jordan, you're recognized for 5 minutes.
Well, Mr. Chairman, I thank you, and I'd like to yield to the ranking member from Louisiana.
Thank you, Mr. Jordan. Thank you, Mr. Chairman. Just real quickly on the procedure, and I'm really grateful. We have benefited in this subcommittee by some great back and forth dialogue. We've agreed it's been some of the most productive because we can talk with really intelligent people about these tough questions, and this one does regard procedure. But I, of course, agree with Ms. Foley, but to show my bona fides as a textualist, okay, I actually do have the text of the Constitution in Article 5, and it says that phrase that Ms. Foley referenced, the mode of ratification may be proposed by the Congress, was referenced in Dillon because they were, of course, quoting Article 5. So at least, I mean, a textualist can look at that in good faith and say, well, that speaks to the Congress having the ability to set a time limit, to do it in a certain way, and if they did it that way, then it would take an equal effort to overturn it. So let me ask each, Ms. Sullivan, Dr. Spearman, and Ms. Arquette, your personal opinion about an unrelated question. Some people are arguing in the Supreme Court this term, as we all know, that the word sex in the federal civil rights laws includes self-professed gender identity. Is it your understanding that the term sex in the ERA also includes self-professed gender identity? And if so, or if not, why is that? Maybe just each of you.
The ERA will prohibit discrimination on the basis of sex. If there's discrimination on the basis of sex in the treatment of gay or lesbian or transgender people, then that will count as unconstitutional under the ERA, just as the Supreme Court is about to decide whether it counts as unconstitutional under the Equal Protection Clause.
What's your opinion on that, though?
I think the proper textual reading of the term on account of sex does include discrimination on the basis of sexual orientation or transgender identity. And that's just a textual reading of the term on the basis of sex.
Okay. Dr. Spearman, do you agree with that?
Yes, I do. I think that when you talk about on the basis of sex, gender identity is a new way of saying this is who I am. But I want to go a little bit further because one of the other hats that I wear is that of an ordained minister. And I believe that and I happen to be a Christian, and I believe that if the founder of my faith were here today, he would probably say something like this: it really doesn't matter because remember I said, whosoever will, let them.
We both believe in redemption. I'm a fellow Christian, but there's different interpretations on the scripture. We'll save that for another day, but I'd love to have coffee with you and talk about it. Ms. Arquette, you agree?
Well, I'm going to answer that in the only way that I know how. My sister, Alexis, was a transgender woman. I spent my whole life sharing a bathroom with her, and the only dangerous thing about it was who was going to use the last of the toilet paper. And my sister, literally, I heard stories after she died of how she broke down bathroom doors to save people from danger. So I love my sister. I want trans people to have equal rights under the law. And the highest group of kids who are getting raped in college are trans students.
I agree, but reclaim my time because we're almost out. But would the ERA include, the term sex in the ERA, does that include gender identity in your view, should it?
I would like it to, but I know that's going to be argued in court. I would like trans people, LGBT people, everyone to have equal rights under the law.
Thank you for the answer. Professor Foley, do you think there may be a reluctance on the part of the majority in this Congress to simply reissue the ERA to the states without any ratification deadline because they know that if that were done, there would follow a torrent of litigation to answer all the dicey legal questions you've presented in your testimony and that we've talked about today?
Yeah, I mean, I think it would happen. It clearly would happen. And I'm pretty confident about how it would come out when it ultimately reaches the Supreme Court. If the ERA is ratified by another state and they purport that that ratification is valid, or if this Congress extends the ratification deadline by simple majoritarian processes and the ratification of the 28th state occurs then, the 38th state, we're going to have a problem on our hands. I think the Supreme Court is going to say that's not a valid constitutional amendment. And by the way, that is not good for the country, I would assume. Nobody really wants a situation where you get all the energy involved in passing a constitutional amendment. It's an important issue. You go to all that time and trouble, and it gets reversed by the Supreme Court. It's not good for the ERA. It's not good for those who support gender equality. It's not good for the country to take the country through that process. If you think this is an important enough issue, you need to do the process right to have it stick.
And wouldn't it set back the prospects for the ratification of future amendments if states knew that Congress could just subsequently alter the terms of ratification?
Yeah, I mean, I think we get ourselves into a giant quagmire and we may never get ourselves out.
Thank you. I'm out of time.
So is Mr. Jordan. Thank you. I recognize Ms. Garcia, an outstanding member from Houston, and will be in her district on Friday. Trying to get, having a hearing on the voting rights amendment.
Thank you, Mr. Chairman. And you know, for me, I sort of go back to back when I was in college and remember still, you know, being the bright-eyed, bushy-tailed student who believed I could change the world. And one of the things I was going to help go do in Austin, Texas, our state capital, was to make sure that all those legislators passed the ERA in Texas. So I was there for that hearing, and who would have thought then that I would be here now today at this hearing, and that we still haven't gotten the darn thing passed. So for me, it's sort of a little deja vu feeling to be here, but I'm so glad that I am, and because the Pennsylvania ladies bragged, I will too, because not only am I here, I'm also here with my friend and colleague, Veronica Escobar, who together are the first two Latinas to ever be elected to the United States Congress from Texas. So we not only have witnessed history, we're making history. But unfortunately, history has not treated us well as women, because even though, as my colleague, the author of the bill, talked about Abigail Adams' note to remember the ladies, obviously, they did not. And that's why we're here today, to correct that, to make sure that the whole world knows, as some of the witnesses have stated, that in this country, we do treat women equally. And Ms. Sullivan, I want to start with you, and before I get to the question, I'm also troubled because I have been involved in the feminist movement for many years, beginning as a law student, and as a student. This whole nonsense of this impacting reproductive rights and this whole idea that the right to an abortion, it may be impacted by the ERA. I mean, you know, I still remember as a law student reading Roe v. Wade and Planned Parenthood and Casey cases and so many after that. The ERA and what we're talking about here today was never mentioning any of those cases, was it?
It was not.
And that would be because it's actually from reading in the right to privacy under the Constitution that those cases were decided. So anything we do with this bill or any future bill on the ERA has nothing to do with the right to privacy.
That's correct.
And do you recall how many times the Constitution uses the word woman?
That would be 0.
0. Well, that's another reason for correcting things today, isn't it?
Yes, it is.
Well, and there's an argument to be made, and I noted that some have said that this whole idea of the deadline, there is no deadline in the actual text of the bill that passed for the ERA, is there?
There is no deadline in the text of the amendment, and
Correct.
that's all that Article 5 speaks to. And there's no, therefore, you can change the deadline because it's only in the preamble.
Right, so is that the best answer to the arguments that Congress cannot just change it? Because in fact, there's nothing to change because it's not in the text?
It's not in the text of the amendment, and to the extent you have the power to put it in the preamble and control your own procedures, what Congress makes for its own procedures, Congress can unmake. And I disagree with my friend Professor Foley that we'd have a lot of litigation on it because the current law is it's non-justiciable, and for good reason. We don't want the court to decide whether amendments are valid or not because amendments are the only way we control the court. You don't want foxes to guard hen houses. You don't want the court to guard the process by which its own decisions can be overruled. And so I don't think it would be tied up in court. I think you have the power, and a court can't strike it down if you exercise it.
Right, and didn't one case actually say that it was the power of Congress to do that?
Absolutely.
Absolutely. Well, I am so glad to hear you say that because it seems to me that the main arguments that I keep hearing this morning, the relationship to abortion and that you can't change the deadline that really wasn't in the text, just seem to go away. And I, for one, have been waiting a long time since I was that bright-eyed, bushy-tailed student. I may not be as bright-eyed and bushy-tailed today as a member of Congress, but I can tell you that I'm going to work like heck to make sure this gets done. So thank you for being here today. Thank you, Mr. Chairman.
Thank you, and Ms. Escobar is recognized presently. She's another star of our freshman class.
Thank you, Chairman. So proud to be here with this room filled with history makers and advocates. I want to thank all of the witnesses who have come before us to testify. I'd like to thank my colleagues, Congresswomen Spear and Maloney, for being such dogged advocates for what is right, what is good, what is just, and what is about time. I'd like to ask the Senator a question because, Senator, you worked so hard. I loved your description of how hard you worked in your state to get this done. And one of my colleagues, Congressman Johnson, asked a witness a little while ago to opine on whether there is popular support or not. I'd like for you to opine, based on your experience in getting this passed in your state, why would anyone be against an equal rights amendment?
Thank you, Congresswoman. You know, it struck me as we were here, the very fact that we're debating equal rights for women is in itself rather abominable, considering we are considered the free nation of the world. So let me just say this. Was it difficult? Yes, it was, because we heard very similar arguments in Nevada. There were people who were afraid, for some reason, that it would expand abortion rights. There were people that were afraid that it would bring about some type of controversy over bathrooms. But the simple matter, it just boiled down to this. The people of Nevada respect, enjoy, and support equality. And so when it came down to the vote, some thought it was partisan, but at the end of the day, we knew it was about equality. That's all it's about. It's about equality. And I have no idea why in God's name this is such a big hurdle to get over. It's about equality. But then, oh, wait a minute, hold on, because I've lived my life in all majority populations. And so when it comes to equality, at every step of the game, I've heard these same arguments. You know, if you do this, then that will mean that black people can drink out of water fountains. If you do that, you know, all of these arguments always come up when we talk about equality. That's the only time it comes up. The people of Nevada stood with me. My colleagues in the Senate stood with me. My colleagues in the Assembly stood with me. And you know what? We even had a Republican governor, and even though he didn't have to sign it, he even put out a statement that he was for equality. So the people of Nevada recognize it's not about putting your hand in the air and seeing which way the wind blows. The people of Nevada recognize it's about equality, period.
Thank you so much, Senator. And to your point, so much of this is rooted in fear, unfortunately. And Ms. Arquette, you and I had the privilege of having a great conversation with you recently. And thank you, by the way, for sharing such personal stories with the public as a way to getting all of us to open up our eyes and feel some compassion. You have made the point over and over again about the economic value of equal rights, equal pay in particular. And I appreciate that you've always pointed out minority women are paid significantly far below even white women. And so I'd like for you to expand a little bit, please, if you wouldn't mind, because that conversation was so powerful, about the economic benefit to equal pay and equal rights.
Well, I think it's pretty crazy. If you're a Latina woman and you're making 54 cents compared to your white male colleague with the same position, you're basically paying a 46% tax, gender tax. And I don't think I could find one man out there where I could say, hey, how about you just take a 46% gender tax? Is that cool? Nobody would accept that. I mean, there's a reason why we have millions more women in poverty when they're old. It follows you your whole life. It impacts you your whole life. And it crosses over itself. Listen, if you're paying a black woman 61 cents on the dollar, so now she's paying what, 39% a gender tax. So she may have to take on an extra job now. So say this woman's a single mom. Now she has to have 2 jobs to make the same amount of money she would have made that her male colleague made. And she's a single mom with 2 jobs. Here's one way it impacts you. Black women are less likely to get breast cancer, but more likely to die from it. And why is that? When you have 2 jobs and you're a single mom, not that all black women are single moms or struggling with 2 jobs, but I'm just saying in this case, to take your time off to take care of your sick kid, you don't have time to take off to go get a breast exam, a wellness exam. So this is killing women. It really is killing women. When we have Native American women and black women dying in childbirth, when we have women not able to get cervical pap smears for completely treatable cancer, because HPV, human papillomavirus, 80 million Americans have it. So when we're closing clinics and we're not giving women access to health care, we're giving them a death sentence. We're going to let people have cancer.
Thank you.
Thank you, Congresswoman. Next, we will hear from Mr. Gomer from Texas.
Thank you. And I don't know of anybody on either side of the aisle that feels like women should be making less than men. I don't know that we need an equal rights amendment to justify or even to, well, it shouldn't be to justify inequality in wages. It ought to be equal, period. But having heard at this hearing that sex in the Equal Rights Amendment includes gender identity, which we know absolutely is not an immutable difference. It's a difference that sometimes someone feels one way, even has sex change operation, later feels another way. It happens frequently. I have friends that have been from one side to another. It does create issues, and as someone who has sat repeatedly as a judge in sexual assault cases, and I've heard the testimony and I've read the medical data, that women are much more likely to suffer, who have been the victim of sexual assault, are many times more likely to suffer from PTSD than male soldiers are. And there's different theories for why that is. and that a woman in a private area, like for example, a restroom, are confronted by what absolutely appears to be a man by all external appearances, is caused to suffer that trauma all over again. I can't fathom wanting to see something passes that forces women over and over against their will in private areas to face men from all biological ways of determining and suffering those traumas again. So I have grave concerns about that. Without an ERA, women will hopefully not be forced into that. With an ERA, from what we've heard today, they will be forced into that. And having lived through the debates over Obamacare and having seen the data indicating that a certain size tumor is found in the UK and in the United States before Obamacare, the U.S. person, whether poor or wealthy, had a 20% chance of surviving than someone in the UK. And if somebody that comes from a home of women, I don't want to see somebody die among my family simply because we adopted some kind of socialized medicine. And as someone who fled Cuba said earlier this morning in a meeting, he forewent the opportunity to have free education and free health care to risk life to get to a place where there wasn't free health care and free education. But Professor Foley, some claim the ERA has wide popular support. If that's so, can you explain why people are pushing this method of reopening the ERA instead of just saying, let's reoffer it, let's get a new time of termination and start all over again? Why is that if it's so popular?
Yeah, I mean, it is a good question. I mean, I don't know the answer. I can speculate. My guess is based on what the proponents are saying today. And I see two themes, okay? And this is from a person, again, who, if you ask me in the abstract if I were a member of Congress, if I would support a proposed ERA in the right procedural way, the answer would be yes. I'm a woman, okay? But would I support it knowing that these sort of sub rosa agendas are being articulated by its proponents today? That would cause me to hesitate. Those two sub rosa goals seem to be, number one, I think trying to entrench abortion and give it a new constitutional status, because there is concern that the new Supreme Court, which is leaning more to the right, is going to roll back some of the protections for abortion. So that concern exists. I think it's probably valid given the fact that the Supreme Court has become more conservative. And I think what they would like to do is sort of have an ERA in there so that it would breathe new life into the right to abortion. Maybe not now with the current conservative court, but certainly laying the seed for the future, that regulations of abortion, late-term abortions, things right now that are passing constitutional muster, maybe later on wouldn't on the basis of that amendment. That's one possibility, and you see them articulate that themselves, so it is what it is. Second thing is, I find it a little bit ironic as a woman that one of the other big sort of sets of proponents of the amendment is the LGBTQ community. I understand why they want it. And I think you've heard from the three members of the panel that they think that if the ERA was passed, that on the basis of sex would include transgender LGBT rights. And I find that a little bit ironic because remember, I mean, we've been historically talking about women's rights, and now I think we're moving a little bit beyond that. So I think that those are the two things I think that give members of Congress concern.
Thank you. I yield back.
Next is my colleague and friend from Houston, Congresswoman Sheila Jackson Lee.
Thank you, Madam Chair, and my long down at the end position on this committee is my desire to be on this committee and take whatever seat I could get, because I knew of the crucialness of this work. And I want to thank Chairman Cohen, and as well, I want to thank full committee chair, Mr. Nadler, and I want to thank Mr. Johnson, the ranking member, for recognizing that women cannot wait. My long litany of questions, let me try to be as pointed and brief as I possibly can. But this brings back memories of the debate of the 13th Amendment. And opposition can be found for anything. Who would imagine that there would be this vigorous debate and this fight, as evidenced by history and the work of President Lincoln, to get this nation to stand against slavery, and the debate, why we should do it. And so I want to be able to answer the question that was asked by my good friend from Texas. We begin this all over again. This will implode the 35 states we already have, because now more attuned to the arguments, there will be a mountain of opposition, false premises, the false premise of abortion, even though the Ninth Amendment and various cases have indicated a woman's right to choose, and we might not even get to the 35 that we already have. So let me thank Congresswoman Spear, whose language is very clear, stating that notwithstanding any time limit contained in the original ERA, the ERA shall be valid to all intents and purposes when ratified by the legislatures of 3/4 of the states. Very simple. And my good friend Carolyn Maloney, who I've stood by all these years, equality of rights under the law shall not be denied or abridged. Simple language that speaks to the necessity of justice. Let me remind my good friend Carolyn Maloney, as I go to my questions very quickly, that we went to Afghanistan and we helped them write their constitution. Many women from this country went, and they wrote in that constitution, that war-torn nation, though we have many, many more miles to travel, the rights of women, and we are still fighting for it in the United States. I'm going to go to Professor Sullivan again and tell me, we have the 14th Amendment, and my time is short. Why do we need the ERA? I want it to be again restated. That is, of course, the equal process, equal rights under the law. Why do we need the ERA?
The 14th Amendment protects all of us equally, but the ERA would protect specifically against sex discrimination. Sex discrimination has its own history, and its history is parallel to in many ways and different in other ways from the history of race discrimination in our country. Nobody ever, sometimes people said women were placed on a pedestal that became a cage when we were protected out of being lawyers or bartenders or sitting on juries or voting, but nobody ever confused a pedestal with an auction block on which people were sold as chattel. So it does honor to our history. The origins of the 14th Amendment expressed our most basic commitment that race discrimination was to ever be ended in America. But we must also state that sex discrimination is to forever be ended in America, and we must state it explicitly and not just do it by analogy to race discrimination.
Let me ask, thank you so very much, Senator Spearman, and thank you for your leadership. I'll convey your regards to my dear friend, council member in Houston, and then to Ms. Patricia Arquette. I want to get my questions on the record so that you can ask and they can be answered. But to Senator Spearman, I imagine you received any manner of threats and accusations as well as distorted opposition. Give us just a snippet, you may have done so already, again, about the possibility of opening this up again, as my good friend from Florida, the professor, and I hope that in this hearing we have convinced her that the idea of any reopening would be a dastardly act as it relates to moving toward our ultimate agenda. And to Ms. Arquette, thank you for your passionate statement. I am a breast cancer survivor. I am well aware of the plight of African American women and all women, and frankly, the Equal Rights Amendment. I'd like to hear from you as to, isn't it about time for us to achieve that place of equality? Senator, please.
Thank you, Ms. Jackson Lee. The opposition that we had in Nevada was very, very similar to the opposition that I heard when I was in high school. The only difference was it had just a little bit more seasoning. There were people who were continuing to say that this would have something to do with women in combat, and women were already in combat. There were some people that said, one lady even came to the stand and said, if we pass the ERA, then that will allow women to marry the Eiffel Tower. I lie to you not. Go back and check the record. Women to marry the Eiffel Tower. And so passing the ERA, when we get this close, the only thing to fear is fear itself. That's the only thing to fear. And as I said before, you know, I find it laughable if it weren't so tragic. People who are born in privilege always debate whether or not those of us who were not deserve equality. And so what we're talking about here, is the fact that equality is not debatable. We are born with it. The only thing we're asking in the ERA is to acknowledge the fact that women are born equal to men. And if you're born in privilege, you have no idea what I'm talking about.
Thank you so very much. Mr. Chairman, would you ask unanimous consent for Ms. Ark to at least finish my answer? I will not ask her a question. I've already done so, but I also thanked you in your absence. I just want to make sure you know how much I appreciate this hearing. Would you? May I, please?
Thank you. While I'd like to be a director and say cut, I ask you to just be brief in your response.
Thank you, Mr. Chairman.
Okay. Let's face it. People didn't want to give women equal rights in the 1870s when there were no abortion laws. They didn't want to give women equal rights in the 1980s when we already had abortion laws. And you don't want to give them to us now in 2019 when we already have abortion laws protecting us. So you just really don't want to give us equal rights. That's really what it comes down to. There are these fears. And do you know how scary it is to be a woman in the United States of America? You're scared of someone might go to the bathroom. Women are being raped everywhere. Kids are being raped on school buses. People are being raped in institutions of God, houses of God. Stop. We can no longer be held back. We need equal rights.
All right, that's a wrap. I now move to enter into the record a letter from the American Association of University Women and a letter and related materials from Helene Swanson on behalf of the organization of Katrina's Dream. Without objection, that will be done. This concludes.
Mr. Chairman.
Yes, ma'am.
May I submit into the record, ask unanimous consent to send into the record a document, ERA, Equal Rights Amendment, frequently asked questions. I ask unanimous consent to put it in, which lists the 15 states that did not ratify.
Without objection, shall be done. And this has been an historic hearing. I've reflected, when I started my political career, which was about 1970, ERA was an issue. It's still an issue. The moral arc of the universe turns towards justice. Slow, but it goes in the direction of justice, Dr. King. So many great witnesses. I thank each of you. I thank our two Congress people for bringing the legislation and for being part of this, but the panel was phenomenal, all four of you. I thank you for your testimony. And I just have to reflect again on Heidi Schreck. I attended that play. It's a great play, and everybody should see it. It was very emotional to me to see the ERA mentioned and how women for so many years have not been a part of the Constitution and have suffered because of it, and the need to change our laws. So with all that, this concludes our hearing.